Good morning, everybody. My name is Annette and I work within the marketing team at HR Assured. Thank you for taking some time out of your day to join our webinar this morning on this business forum. Today, if you're not familiar with HR Assured, it's a part of FCB Group. We help businesses navigate around Australia and New Zealand's complex employment laws by providing a range of services and products to ensure businesses are compliant. If I could just get the next slide up. Thank you. Okay, so today's webinar will be presented by our Senior Workplace Relations Consultant and Solicitor, Bethany Silverman. Today, Bethany will take you through some key information about the public health orders and managing people during this difficult time. At the end of the session, we'll have some time to answer some of your questions. Please note that at the bottom of your screen there, you've got a Q&A function. It's on the far right there. If you do have a question during this presentation, type your question there and we'll get to that at the end of the session. So I'm going to make a start. I'll hand over to Bethany.
Perfect. Thank you, Annette. And thank you everyone for taking the time out of your very busy days to attend this webinar. So today we will be focusing on the current lockdown affecting New South Wales and what this means for businesses, the importance of workplace health and safety of your employees, employee management and the restrictions affecting the businesses, how to enact a stand down, employee payment options, and then as Annette said, we'll have some time for questions at the end. So as we are all aware, currently in New South Wales, there is a significant outbreak of COVID-19. At present, or as at 8 p.m. last night, there were 2,512 cases in New South Wales that are active. Since January 2021, January 2020, there have been 8,342 cases of COVID-19 in New South Wales. And yesterday, unfortunately, New South Wales saw the greatest case numbers to date, being 240 new cases that were acquired locally. So the restrictions are constantly changing, which makes it quite difficult for businesses to keep up. So as at the 29th of July, there has now been an additional 4-week period of lockdown announced, which means the restrictions will last until at least Saturday, the 28th of August. Stay-at-home orders are in place unless somebody has a reasonable excuse to leave home. And there are also special rules which apply to residents in the Fairfield, Liverpool, Canterbury, Bankstown, Blacktown, Cumberland, Parramatta, Campbelltown and Georges River local government areas. Non-critical retail businesses have now been closed. Last week, construction work was halted. However, the New South Wales government has now announced that construction in non-occupied settings outside those local government areas that I just mentioned can reopen as planned, but there is a 1 person per 4 square metre rule. And this week, the New South Wales government also announced a singles bubble, which allows people who live alone to nominate a designated family member or friend to visit for companionship. However, there are specific rules which apply to those people in the relevant local government areas. So the stay-at-home orders that are currently in place apply to residents of Greater Sydney, including the Blue Mountains, Central Coast, Wollongong and Shell Harbour. As I said, people are only allowed to leave home if they have a reasonable excuse, which I'll go through shortly. People in the affected local government areas, so Fairfield, Liverpool, Canterbury, Bankstown, Blacktown, Cumberland, Parramatta, Campbelltown and Georges River, are not able to leave their local government area unless they are an authorised worker. Residents of Greater Sydney must get tested every 7 days if they work 50 kilometres outside of Greater Sydney. And occupiers of workplaces 50 kilometres outside of Greater Sydney must not allow a Greater Sydney worker to attend their workplace unless they can show that they've had a negative test result within 7 days. So what are the reasonable excuses? So this includes leaving home to obtain food or other goods or services in your local government area or within 10 kilometres of your home. You can leave for the personal needs of the household or other household purposes, including pets, if you are a vulnerable person, and only one person per household may leave the home to obtain food or other goods and services each day. However, you can take a dependent person, such as a child, with you if that person can't be left home on their own. People can leave home to go to work if they cannot reasonably work from home. However, if they are an authorised worker living in one of those affected local government areas, there are additional restrictions that apply. So you must be an authorised worker in order to leave the local government area. If you work within the local government area that you live in, however, you can still go to work. And from Thursday, the 29th of July, restrictions also apply to authorised workers living in the Campbelltown, Georges River and Parramatta local government areas. Other reasonable excuses to leave home include attending education, if you cannot do that from home, exercise and outdoor recreation within your local government area or up to 10 kilometres from your home, and also to go out for obtaining care, or medical reasons, including obtaining a COVID-19 vaccination. So I'll go through some of the restrictions affecting these local government areas. So as I said, people can still leave home to attend work where it's not reasonable for them to work from home, provided that the attendance at the workplace is within the local government area. If you are an authorised worker, you can leave the impacted local government area. However, there are restrictions and testing requirements as well. So some examples of authorised workers that the New South Wales government has defined include supermarkets, including bottle shops, shops that predominantly sell food or drink, chemists and pharmacies, office, pet, baby, medical or pharmaceutical suppliers or stores, hardware and building supplies, landscaping materials and garden centres, and fuel retailing. And this also applies and extends to health workers and aged care workers as well. So there are COVID-19 testing requirements for authorised workers. This information is critical and is in force as of the 29th of July. But as I said, there are a lot of changes that are constantly being made. So this may change in the coming days. So for Canterbury Bankstown workers, if you live in or stay in this local government area and work outside this local government area, from the 29th of July, you must have a COVID-19 test once every 72 hours or 3 days in order to be able to attend work as an aged care or healthcare worker. And from Saturday, the 31st of July, you must have a COVID-19 test once every 72 hours in order to be allowed to go to work as an authorised worker. So they're essentially expanding the requirements for people to obtain or to attend work outside the local government area. In the Cumberland area, with respect to aged care and healthcare workers, from Saturday, the 31st of July, you must have a COVID-19 test once every 72 hours in order to be able to go to work as an aged care or health worker where you live in or stay in this local government area and have to leave that local government area for work. There are ongoing COVID-19 testing requirements for people in the Fairfield local government area. So for those people who live in that area and work outside that area, from the 29th of July, you must have a COVID-19 test once every 72 hours in order to be allowed to leave the local government area as an authorised worker. And from Saturday, the 31st of July, you must have a COVID-19 test once every 72 hours in order to leave the local government area as an aged care or health worker. So there is a lot of repetition in these requirements, but as I said, it could change and it could be clarified further. Other restrictions on authorised workers who are living in or staying in the Blacktown, Campbelltown, Canterbury Bankstown, Cumberland, Fairfield, Georges River, Liverpool and Parramatta local government areas should also get tested if they have any symptoms of COVID-19 were at a location at the same time as a confirmed COVID-19 case, have come into contact with a confirmed case, or are working more than 50 kilometres from the Greater Sydney area. So some further examples of authorised workers also includes businesses operating click and collect services, public administration and safety, healthcare and social assistance, education, schooling and early childhood, manufacture of food, beverage, groceries, cleaning and sanitary products, manufacture of medical equipment, manufacture of telecommunications equipment and infrastructure, transport, postal and warehousing businesses, electrical, gas, water and waste services, information media including IPS, data specialists and journalists, and also maintenance, safety and upkeep of public and recreational spaces. There is also a full list of authorised workers on the New South Wales Government website, which is really handy to refer to. So there has also been financial support for workers announced by the federal government and also the New South Wales government. So as of the 29th of July, there are a few different types of payments which people may be eligible for. So this includes the Pandemic Leave Disaster Payment, which is a New South Wales government payment. And there is then the COVID-19 disaster payment, which has been announced by the federal government. And there are specific eligibility rules and criteria which apply to different states in different ways. But in this webinar, I will just focus on New South Wales. So the Pandemic Leave Disaster Payment. So this is for eligible people who are directed to self-isolate or quarantine after the 17th of September 2020 because the person has COVID-19, has been a close contact of someone with COVID-19, or cares for a child under 16 years of age with COVID who has been a close contact. The person receiving the payment must be at least 17 years old. They must be an Australian resident or visa holder. They must be unable to work, and they have no appropriate leave entitlements which they can take, including pandemic sick leave or personal carers leave. And they may be eligible to receive up to $1,500 for each 14-day self-isolation or quarantine period. The COVID-19 disaster payment is a lump sum payment for people who have lost work and income due to the New South Wales COVID-19 public health orders. The type of payment that the person may be able to receive and how much they can receive is dependent on whether they also receive a Centrelink payment as well. So these are some new criteria that have been introduced. So for those who do not receive a Centrelink payment, the eligibility criteria are that they must be an Australian resident or hold a visa which gives them the right to work in Australia. They must be 17 years old, not receiving any income support payment, AB study living allowance, dad and partner pay or parental leave pay. They cannot be receiving the Pandemic Leave Disaster Payment, a state or territory pandemic payment, or a state small business payment for the same period. And they must be able to show that they've lost hours of work and income due to the lockdown in their state and don't have any appropriate paid leave entitlements. There has been clarification on the definition of appropriate paid leave entitlements. And that does not include annual leave, personal leave, or long service leave payments. So it's really referring to any other kind of pandemic payment which the person may receive. If the person does receive a Centrelink payment, then the eligibility criteria are that they get an income support payment, AB study living allowance, dad and partner pay, or parental leave pay, 17 years or older. They're not in receipt of the Pandemic Leave Disaster Payment, a state or territory pandemic payment, or a state small business payment for the same period. They live in or work in a Commonwealth declared COVID-19 hotspot and that is subject to a state restricted movement order. they were unable to work and earn their usual income of 8 hours or more or a full day's work because they were in that hotspot and are subjected to restricted movement, and they do not have any appropriate paid leave entitlements. There has also been some increases to the amounts payable. So for those who do not receive a Centrelink payment, so for the period of 22 July to 28 July, the payments for someone who's lost less than 20 hours of work per week is $375. And that also applies if they've lost a full day of their usual hours of work that week. If they've lost more per week, then they may be eligible to receive up to $600. The same criteria will apply for the period of 29 July to 4 August 2021. But from the 5th of August to the 11th of August, and then after that as well, where they've lost less than 20 hours of work per week or a full day of their usual hours that week, they may be eligible to receive $450. And if they've lost 20 hours or more in that relevant period, they may receive $750. If somebody is in receipt of a Centrelink payment, they would only be eligible to receive up to $200 each week on top of their regular payment. So I will go through how to enact a stand down. So a stand down will be affecting many businesses within New South Wales that are not able to operate. So under the Fair Work Act, to stand an employee down, an employer needs to be able to show that there is a stoppage of work. The employee that is going to be stood down cannot be usefully employed because of the stoppage of work. And this is not limited to the work an employee usually performs. And the reason for the stoppage of work must be one that the employer cannot reasonably be held responsible for. Now, it's important to remember that employers generally can't stand down employees under the Fair Work Act simply because a deterioration of the business has occurred as a result of the lockdowns or because the employee has coronavirus. And it's also important to remember that if an enterprise agreement or employment contract applies to the employees and allows the employer to stand them down because of a stoppage of work, that enterprise agreement or contract will apply rather than the conditions and terms within the Fair Work Act. In terms of payment during a stand down, employees who have been stood down are not entitled to payment of their ordinary wages. And they also cannot use sick leave during a stand down. However, they can use other types of leave by agreement with their employer, such as annual leave, long service leave if they have reached that entitlement, and any other form of paid leave under the relevant modern award, enterprise agreement, or employment contract. Leave entitlements like sick leave, carers leave, and annual leave will still accrue while the employee is stood down, and it will accrue as if they had not been stood down. It's also important to remember that time away from work due to a stand down counts towards an employee's service. So this means that that time is stood down when calculating their entitlements under the National Employment Standards, including notice, redundancy, and leave. So we'll go through any questions that have popped up now.
Thanks, Bethany. I do have a couple of questions that come through. You were talking earlier about not being able to use sick leave or in a stand down. Can you explain that more and what happens if someone is sick during that time? What can they do? Can you elaborate?
Yeah, absolutely. So there was a recent case heard through our court system which confirmed this. So essentially, in order to use sick leave, the test is that the employee is unfit for work due to an illness or an injury. Where somebody is effectively stood down from work, there is no work to be performed, and as such, it doesn't trigger the entitlement to take sick leave. So unfortunately, even if they do become ill during a period of stand down, they would still not be entitled to take sick leave.
Okay, thank you. We have a question here about casuals being stood down. So what is the approximate protocol? Like, what's the protocol there? What do you do in that circumstance?
Yeah, absolutely. It's not necessary to stand casuals down in such a formal manner. Rather, we would recommend that casuals are informed that at the present time, there is a reduction in the amount of casual shifts available, or there are no casual shifts available as a result of the lockdown or the restrictions that are in place.
Got you. Okay. This is a good question. Can you please talk about the employer's responsibility regarding mental health for those working from home in an office kind of environment?
Yeah, absolutely. And this is one that comes up quite a lot. It can be quite isolating working from home, particularly if you live by yourself. So employers should take steps to schedule regular meetings with employees when you are in a lockdown and working from home. Scheduling things like Zoom meetings or Teams meetings where people are able to put a camera on if they wish in order to connect with their colleagues and their managers is really, really helpful in reducing any additional stresses related to mental health. Just helps people to feel connected. If an employee raises with you that they are feeling quite stressed or experiencing some mental health concerns, because of the lockdowns, then employers should take proactive steps to manage that. So providing them with access to an employer assistance program or an EAP provider can be really, really helpful. They have effectively through that service would get access to counselling. Also providing materials like the Beyond Blue or Lifeline number is really helpful as well. And then also just having regular check-ins, making sure that they know you're there to support them as well.
Thank you, Bethany. We have a question here about an employee. Can an employee enter Blacktown local government area where the business is that they work for if they live outside any of the affected LGAs?
Yeah, so the information is quite unclear at this point in time, but it would appear if you're living outside those local government areas, you can still go into one of the affected areas for work. However, if somebody is ordinarily working there or living there, they would need to get regular testing done.
Okay. Hopefully that answers your question. Okay, if someone was due to start a new position, a part-time position, 2 days per week, and then lockdown happened, are they eligible to claim any benefits?
They may be able to, but it would really be something that they need to contact the relevant body administering that payment through. So it could be that they contact Services New South Wales, or if it's a Centrelink Payment Services Australia, to get further clarification. At present, the eligibility criteria is that the person must have lost a certain amount of work in order to claim, for example, the COVID disaster payment. They may not be able to show that they have lost work when they have not actually commenced work, but it would be something for that body to actually determine. It's quite difficult with the criteria that has been put up at the moment. It's very vague and unclear.
Okay. How should a stand down be reflected in a pay slip, a payment towards during lockdown? I think I've said that correctly. So essentially they're paying their employee during the lockdown.
Yeah, so if a business has chosen to continue to pay employees throughout a lockdown, even though the business can't operate, and the employees are effectively stood down, they've just elected to keep paying them. It would just be reflected as ordinary hours. If there is an ability through your payroll system to put a note in, we would recommend doing so and just having a note on the pay slip that, employee has been stood down and the employer has elected to continue paying them for that period. It would also be recommended that when you're confirming the employee has been stood down, that you do that in writing, and then you reflect that we have elected to continue paying you for the period of, this date until this date, so that you can then say later down the track, if the lockdown gets extended and you're not in a position to continue paying them, that you can say, our previous letter said we would pay you for this period. We're no longer in a position to continue doing that, and we will no longer be paying you whilst stood down. And you can, explore your eligibility to claim any other type of payment which may be available at that point in time.
Great. Okay. Employees on disaster payments. Is the employer required to top up their pay to the normal wage? And if so, can you get this? Can they use their annual leave?
Sure. So with the COVID disaster payment, from our understanding, there's no obligation on an employer to top up the employee's wage. They would simply receive the payment that they would be eligible to receive based on the hours of work that have been lost. The employee could elect to take a period of annual leave to top up their pay if they wanted to, but there's no obligation to do so.
Okay. Okay. Just going to read this one. Okay. Can you explain what employers are entitled to besides one-off grant and 40% off reimbursement of wages, business support? We are still at a loss. It says somewhere that employees can still apply for disaster payment even if the employer gets business support.
Sure. So we haven't focused on what employers are entitled to claim because the eligibility criteria are constantly changing. So we do recommend going to the relevant government body to actually get some confirmation on that. I know that's not super helpful, but it's not something that we can really explain what you are or are not entitled to.
Okay, thank you. If an employee is unable to perform work in New South Wales, not in a hotspot, due to Vic border closures because the client returned to Vic, is the employee eligible for disaster payments?
Sorry, Annette, you just cut out for me a little bit there. Would you be able to repeat that one?
Sure, no worries. If an employee is unable to perform work in New South Wales, not in a hotspot due to Vic border closures because the client returned to Vic, is the employee eligible for a disaster payment?
If they are not able to work because they've been either directed to self-isolate or they can't get back into the state, or they've gone somewhere else, or they are otherwise directed not to work, they may be able to receive the COVID disaster payment, but it would be more likely that they would need to be taking unpaid pandemic leave if they've been directed to isolate or not able to work for some sort of restricted reason.
Okay, thank you. There's a question in the chat here, and I'm not sure if you can answer it, Bethany, but it's more about patients in the medical industry. Okay, do you know if a patient from a lockdown LGA, e.g. Parramatta, can the patient still come outside to see a clinician for essential medical treatment? Do they have to have a COVID test prior to coming? I don't know if that's something you can answer.
It's a really good question, again, and it's something that we're seeing a lot with the New South Wales restrictions that are in place. They are quite vague. Our understanding is that you are still allowed to leave your home, even if you are in one of those areas, for authorized or essential reasons, which does include obtaining essential medical treatment. However, the recommendation is that people should not leave the local government area unless it's absolutely a requirement. So, if they can see a medical practitioner within the local government area, that would be recommended. We would recommend, though, double checking with the New South Wales Department of Health beforehand, because the situation is just evolving so rapidly.
Great. And one last question, unless any more come through. I think it's more around stand down again. So an employee, can they use annual leave during the stand down? They can. Is that
yes.
what you did, right? I remember you saying that. Okay, cool. I think that's everything. Oh, we've got another one. Got another one. Okay. For a dental practitioner, is professional indemnity insurance to be kept paying when stood down? I think they're saying, should they continue paying their insurance?
Yeah, so that one is a little bit outside of scope for this webinar, unfortunately. It's unclear from our perspective, but we would recommend contacting the insurer to confirm.
Great. Just going to chew another check. Okay. Oh, here's another one. If a worker is living in the border community between New South Wales and Vic, will they be eligible for the New South Wales disaster payment or Vic disaster payment if they live in New South Wales but work in Vic?
Well, that's a really, really good question, actually. I think it's probably one of those ones that, again, is quite unclear, which seems to be a bit of a trend with the current restrictions, and it's hard to keep up. They may be eligible for the New South Wales one if they ordinarily work in New South Wales, but we would recommend contacting the relevant body to confirm there. Unfortunately, they haven't put out any kind of clear rules or legislation. So for example, with JobKeeper last year, we had legislation which made it a little bit easier to interpret what the rules were, but at present there's just sort of one website that doesn't have a lot of information available.
Okay, great. Okay, I think that's all the questions, Bethany. I'll just get you to go to the next slide because...
Sure.
Okay. So I just want to offer anyone who is not already a HR assured client or, the opportunity to try our advice line for free. If you do need some workplace advice, we will and can assist you. Someone in our team will be in touch after the webinar to arrange this. So we'll be sending you that link on the screen there, and we'll also be sending the recording to you as well. If you'd like to watch this again or share it with anyone who you think may benefit from this. This is going to be a regular forum to keep in line with any latest information that comes through. So do look out for the dates. We post them on our social media pages, and we also send them out via email. There is one more last question coming through. Let me just have a look here. Okay, my husband is stood down and can't work in the affected LGA. Can he claim disaster payment while I also claim for my business disaster payment?
If he's just claiming for himself, he should be able to. There are some additional restrictions on people who are couples and making claims, and those criteria are outlined on the Services New South Wales website.
Okay, great. Well, thank you, Bethany. That's all the questions. I don't think anything else is coming through. But we do hope that you found this information useful. If you do need that support and advice, please reach out to us. And thank you to our existing HR assured clients for your support. And as you know, you already have access to the telephone advisory service. So please use that if you do need to talk to us.
Perfect. Thank you, everybody, for your time, and have a lovely day.
Thanks.